Hello everyone, welcome back to the video lecture on paper number 5, Business Law and Ethics of CMA Inter. In previous lectures, we covered part A of this study material. Today, we are entering into part B, that is industrial laws. I would suggest my students to always, when they are studying in an examination point of view, have an idea of how much weightage each part contains. For example, if you look into your study material, part A in question paper, there will be 30% of the marks coming from part A. Whereas part B, you can expect 15% of the mark, part C, 40%, part D, 15%. What this means is there is 6 chapters in part A. There is 5 chapters in part B. So if you study 11 chapters, you are studying for 55 marks, 45 marks. 11 chapters contribute 45 marks. Whereas just 2 chapters, they contribute 55% of the marks. So we should be very well aware on what we are spending our time on. So in the previous 6 lectures, what we have discussed, we were studying for 30% of the marks. The next portion will be for 15%. So why we are discussing this is because students, when they study, they are giving equal importance to every point of the study material, which is good from a professional view, whereas from a preparation of examination, you should be very well aware on where you are spending your time. Because whatever time you are allocating, you should be able to get productivity from that hour. So we should be able to prioritize depending on the importance of the topic and weightage. So here we start part B, industrial laws. Today we'll discuss about Factories Act 1948. Here you can expect any one word question or a direct question. Where is Factories Act applicable? What is the number of employees required for a Factories Act to be applicable? Likewise, who is a occupier? Who is a competent person? What is a hazardous process? That will be the important aspect to be covered in this lecture. So it will be helpful if you have a note. You prepare note for each chapter. So you'll be able to, before the exam one day, you will be able to cover the chapter quickly as possible. The main object of Factories Act 1948 is to ensure adequate safety measures and promote the health and welfare of employees employed in the factory. It is as simple as that. Who is a competent person as per for Factories Act? Section 2, Clause CA defines expression competent person in relation to any provision of this Act means a person or an institution recognized as such by Chief Inspector for the purpose of carrying out test, examination, and inspection required to be done in a factory under the provisions of this Act, having regard to qualification and experience of the person, facilities available at his disposal, qualification and experience of the person employed in such institution and facilities available therein, with regard to the conduct of such test and examination and inspections, and more than one person or institution can recognize as competent person in relation to a factory. So, so competent person is the person in recognized by chief inspector for the purpose of carrying out text examination and inspection. Who is what is an hazardous process? Defines the expression hazardous process as the process or activity in relation to industry specified in first schedule, where unless special care is taken, raw materials used therein or the intermediate or finished products, byproducts, waste or effluents thereof would cause material impairment of to the health of the person engaged in connected therewith, result in pollution of general environment. The state government may, by notification in official gazette, amend the first schedule by way of addition, omission, or variation of any industry specified in the schedule. So, you may know in a factory, those who are employed may face any hazardous or health issue, or it may happen environment may get affected because of the activity of the factory. So, Factories Act has identified what is a hazardous process. It is defined in Schedule A. You can see it, first schedule of Factories Act. What is a manufacturing process as per Factories Act? Section 2, Clause K defines expression manufacturing process as any process for making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing, or otherwise treating or adapting any article or substance with a view to its use, sale, transport, delivery, or disposal, or pumping oil, water, sewage, or any other substance, generating, transforming, or transmitting power, composing type of for printing by letterpress, lithography, photogravure, or other similar process or book building. Constructing, reconstructing, repairing, refitting, finishing, or breaking up ships or vessels, or preserving or storing any article in cold storage. So you can go through what is a manufacturing process because it has been repeatedly asked what is a manufacturing process. If you could reproduce any of these points, it would be good. Who is a worker as per Factories Act? Section 2, subclause 1 defines the term worker as a person employed directly or by or through any agency, including any contractor with or without the knowledge of principal employer, whether for remuneration or not, in any manufacturing process, in cleaning any part of the machinery or premise used for manufacturing process. These are all definitions. What is a factory as per Factories Act? Factory as any premises including the precedence thereof wherein 10 or more employees are working or were working on any day preceding 12 months, wherein any 20 or more persons or workers are working on any or were working on any day on the preceding 12 months or any part which is a manufacturing process is being carried out on without the aid of power is ordinarily carried on but does not include a mine subject to the Mines Act or a mobile unit belonging to the armed forces, union, railway running shed, hotel, restaurant, or eating place for computing number of workers for the purpose of this clause. All the workers in different groups realized in a day shall be taken into account. For the purpose of this clause, the mere fact that electronic data processing unit or a computer unit is installed in any premises or part thereof shall not be construed to make it factory if no manufacturing process is being carried on in such premises or part thereof. So, what is the point of this? You should understand why we are studying this. So, we have a definition of factory in Factories Act. So, if you have an establishment or a business, if you are coming under the definition, you are obliged to comply with the provisions of Factories Act. In other way, where is Factories Act applicable? Factories Act is applicable to a factory where 10 or more workers are working or were working on any day for the of the preceding 12 months, or in any part of which a manufacturing process is being carried on with the aid of power or its ordinary so-called, wherein 20 or more persons are worked or working on any day preceding 12 months in any part of the manufacturing process is being carried on without any paid of power. If there is an aid of power, minimum 10 or more. If there is no power, minimum 20 or more. If there is more than 10 or 20, depending on aid of power, factories are act become applicable. But there are certain exemptions for Factories Act. What are they? Mines under Mining Act, armed forces of the Union like military, running shed, hotel, restaurant, and eating places. Okay. Who is an occupier? Defines section 2 subclause N defines the term occupier of a factory as the person who has the ultimate control over the affairs of the company, is the boss. In case of a firm or an association of individuals or any other one individual partners or members thereof shall be deemed to be an occupier. In case of a company, any one of the directors shall be deemed to be the occupier. In case of a factory owned or controlled by central government or state government or local authority, in the person appointed to manage the affairs of the factory by the central government or the such authority as shall be deemed to be occupier. In case of a ship which is being repaired, the maintenance work is carried out in a dry docket wherever which is available for hire. The owner of the dock shall be deemed to be the occupier. So the ultimate authority is the occupier. In case of a firm, an individual partner may be the occupier. Company, a director may be the occupier. In case of a company, it is a director who shall be. So, in case of a government-controlled company or a establishment, any person deputed to be the occupier by the government or such authority. Every occupier, what are the duties of an occupier? Every occupier shall ensure, so far as is reasonable practice, the health, safety, and welfare of all workers while they are in work at the factory. Who is an inspector as per Factories Act? Section 8 provides that state government may appoint such person as possess the prescribed qualification to be the inspector for the purpose of this act and may assign to them such local limits as it may think fit. Section 9 prescribes the powers of the inspector as is detailed below to enter into place where which is used or be which has reason to believe is used as factory, make examination of premises, plant, machinery, article, substance, inquire into the accident or dangerous occurrence were resulting in bodily injury, disability or not, and taking on account on the spot statement of any person which he may consider necessary for such inquiry, require require the production of any document relating to factory, seize or take copies of the register, record any or other document or any portion thereof as he may consider necessary to take possession of any article or substance or part thereof detailed in for as long as is necessary for such examination to exercise such power as may be described. So, inspector is a person appointed by the state government for inspecting factory premises. That person can enter into factory premises at any time during, as prescribed under law. He can examine the premises, inquire any accident, require any production of documents, seize and take copies of registers and direct records and other documents, take possession of any articles of substance, etc. Certified surgeon. Section 10 provides that the state government may appoint qualified medical appointers, practitioners to be certified surgeons for the purpose of the Act within such local limits or for such factory or class or description of the factories as it may assign to them respectively. The duties of the certified surgeons are as follows: the examination and certification of young persons, the examination of person engaged in factories in such dangerous occupations or processes as may be prescribed, exercising of such medical supervision as may be prescribed for any factory or class or description of factories where case of illness have occurred which is it is reasonable to believe are due to the nature of manufacturing process carried on or other conditions of work prevailing therein by reason of any change in manufacturing process carried on or in substance used therein, or by reason of the adoption of any new manufacturing process or of any new substance for use in manufacturing process, there is a likelihood of injury to the health of workers employed in that manufacturing process. Young persons are about to be employed in any work which is likely to cause injury to the health. So, central government, state government can appoint qualified medical practitioners to be certified surgeons for the purpose of the act within such local limits. The duties are examination of and certification of young person, and examination of person engaged in factories. If so, there is, in case of there is dangerous occupation involved, or exercise such medical supervision as may be prescribed. Factories Act speak about many welfare measures, which includes health of the workers in the working environment, safety of workers included in the hazardous process, welfare of workers, and working hours of adults, employment of young person, annual leave. These are all welfare measures included in Factories Act. Health. Chapter 3 of Act deals with the measure to take consider of the health aspects of the workers. The following are to be taken care by the occupier of the factory. So, what are the things to be taken care by the occupier? Cleanliness, disposal of waste, ventilation, dust and fume, artificial humidification, overcrowding, lighting, drinking water, laterals and urine spittoons. So, we are going to dive into each of this point. So, Factories Act mandates certain protocol to be maintained in a factory. As far as cleanliness is concerned, every factory shall keep clean and free from effluvias, effluvia arising from any drain, privy, privy or other nuisance, and in particular, removal of accumulated dirt, cleaning of the floor, providing effective drainage, ensure interior walls and roofs are kept clean. Whitewash or color wash should be carried out at least once in every 14 months. So these are all the points you can expect one mark or a direct question you can expect. Whitewash, what period during we have to carry out? 14 months. You can take note of that. Where surface has been painted or varnished, repair or revarnish shall be carried out once in every 5 years. If there is surface is painted and varnished, then once in 5 years. If it is whitewash or color wash, it shall be once in 14 months. Where they are painted or varnished or where they have smooth impervious surface, should be cleaned once in every 14 months by such method as may be prescribed. But if painted and varnished, okay, but smooth impervious surface means it is a kind of surface in interior part of the factory. If it is such condition means you should have to do it again in every once in 14 months. All doors and windows and other framework which are wooden or metallic shall be kept painted, varnished at least once in every 5 years. So this aspect you have to take note. Okay. Disposal of waste and effluents. Section 12 provides that effective arrangements shall be made in every factory for the treatment of waste and effluents due to the manufacturing process carried on therein, so that as to render them in course for their disposal. Ventilation and temperature. Section 13 provides effective and suitable provisions shall be made for every factory for securing, maintaining every workroom with adequate ventilation by circulation of fresh air at such a temperature as will secure to workers therein reasonable conditions of comfort and prevent to health in case work involves the production Excessively high temperature, adequate measures shall be taken to protect the workers by separating the process which produces such high temperatures from the workroom by insulating the high hot parts from the effective means. So there shall be ventilation and effective when temperature management. Dust and fume provides section 14 provides every factory if there is a given of any dust or fume or any other impurity of such nature in process of manufacturing, it is likely to be injurious or offensive to the workers employed, or any dust in substantial quantities offensive to workers. Effective measures shall be taken to prevent its inhalation and accumulation in any workroom. Exhaust appliance shall be applied as near as possible to the point of origin of dust, fume, or other impurity, and such points shall be enclosed as so far as possible. In case of dust and fumes, you should have an exhaust mechanism. Artificial humidification. Section 15 provides that if the humidity of the air is artificially increased, the state government may make rules, prescribe standard of humidification, regulate the method used by for artificially increasing the humidity of the air, direct prescribed tests for determining the humidity of the air to be correctly carried out and recorded, prescribing methods to be adopted for securing adequate ventilation and cooling of the air in the workrooms. Overcrowding. Section 16 provides that no room in any factory shall be overcrowded to an extent injurious to the health of the workers employed therein. There shall be every workroom in a factory shall at least 14.2 cubic meters of space for every worker employed therein. This is the important point. For every worker, there should be 14.2 cubic meter space. Lightning. Section 17 provides that in every part of the factory, workers are working on or passing there shall be provided and maintained sufficient and suitable lighting, nature or artificial or both. All glazed windows, skylights used for lighting shall be kept clean on both the inner and outer surface and free from obstruction. Effective provision shall be made for prevention of glare, either directly from a source of light or by reflection from a smooth and polished surface, and the formation of shadows to such an extent as to cause eye strain or risk of accident to any worker. So, understandable, no? This is very well important. Drinking water. Section 18 provides that effective arrangement shall be made to provide and maintain at suitable points, conveniently suited for all workers employed, a sufficient supply of wholesome drinking water. Where more than 250 employees are employed, provision shall be made for cooling water during hot weather. The water point shall be away 6 meters from any washing place, urinal, rattles, spittoons, open drain carrying sillage, effluent, or any other form of contamination. So, effective drinking water supply should be the where there are more than 250 employees working, there shall be a provision for cool drinking water in during hot weather, and also it shall be 6 meters away from any contamination. Lateral and urinal. Section 19 provides that in every factory, sufficient lateral and urinal accommodation of prescribed procedure types shall be provided conveniently suited and accessible to workers at all time while they are at work factory. Yes, separate enclosed accommodation shall be provided for male and female workers. They shall be adequate lighted and ventilated. They shall be maintained in a clear and sanitary condition at all time. Sweepers shall be employed to keep clean laterals and urinals and washing places. If there are more than 250 employees employed, all laterals and urinals shall be prescribed types. The floor of interior walls and sanitary blocks shall be laid in glazed tiles to provide a smooth, polished, impervious surface. The laterals and urinals shall be washed, cleaned at least once in every 7 days, while suitable detergents and disinfectants or with both. As far as bathroom or washroom is concerned, laterals and urinals, you should take proper care. If there is more than 250 employees involved, then additional compliances will come. You should make sure once in 7 days proper disinfection is happening. Spittoons provides that there shall be provided a sufficient number of spittoons in convenient places. They shall be maintained in a clean and hygiene conditions. Safety. Chapter 4 of the Act prescribes the procedure to be adopted on the safety of the working place or in a factory. The factory is to take safety measures in respect of the following: fencing of machinery, work on or near machinery in motion, employment of young persons on dangerous machines, strike gear and devices for cutting of power, self-acting machines, casing of a new factory, prohibition of employment of women and children near cotton openers, lifting machine, chains, ropes, and lifting tackles, revolving machines, floor stairs or means of access, pitch sumps opening in a floors, excessive weights, protection of eyes, precaution against dangerous fumes, gases, etc., precaution regarding the use of portable electric lights, explosive or inflammable dust gas, etc., precaution in case of fire, safety on building and machinery, maintenance of buildings, appointment of safety officers. These are all the safety aspects as per chapter 4. Hazardous process. Chapter 4a provides for making provisions relating to the hazardous process. The state government may follow may for purposes of advising it into consider applications for granting of permissions for the initial location of a factory involving a hazardous process or for the expansion of such factory appoint a site operational committee. The site operational committee shall examine a application for the establishment of a factory involving hazardous process and make it recommendation to the state government. Within 90 days of receipt of such application, the committee shall have power to call for any information from the person making an application. When the application is got approved by the state government, it shall not be obtained. It shall not be necessary to obtain a further approval from the state central board of state or central board of the state board of pollution authorities. What are the responsibilities of an occupier? The occupier has to follow following procedure: lay down detailed policy with respect to health and safety of workers, to disclose all information regarding dangerous, including health hazard or and the measures to overcome such hazards arising from exposure to or handling of materials or substances in the manufacture, transportation, storage, and other processes to the workers employed in the factory, to draw up on-site emergency plan and detailed disaster control measures for the factory and make known to the workers and to a general purpose living in the vicinity of the factory the safety measures required to be taken in event of accident taking place, to lay down measures for the handling, use, transportation, storage hazardous substance inside the factory premises and the disposal of such substances outside the factory premises, and publicize them in manners prescribed among the workers and general public living in the vicinity. There are certain welfare aspects of factories act. What are they? Chapter 5 provides welfare measures to be taken in a factory for workmen employed in the factory. The following are the welfare measures prescribed in the Act to be provided by the factory to the workmen: washing facility, facility for storing and drying clothes, facility for sitting, first aid appliances, canteen, shelter, restroom, and lunch rooms, crunches, appointment of welfare officers. Now I'll be diving into each of the points. Section 42 provides every factory adequate and suitable facility for washing shall be provided and maintained for the use of workers. Separate and adequate screened facility shall be provided for the use of male and female workers. Facility for storing and drying clothes. Section 43 provides state government may, in respect of factory or class of description of factories, make rules requiring the provision therein of suitable places for keeping clothes not worn drawn during working hours for drying of wet clothes. Facility for sitting. Section 44 provides suitable arrangement for sitting shall be provided and maintained for all workers obliged to work in a standing position in order that they may take advantage of any opportunity for rest which may occur in the course of their work. First aid appliances. Section 45 provides first aid appliances shall be provided and maintained so as to readily accessible during all working hours or cupboards equipped with prescribed contents and number of such boxes and cupboards to be provided maintained shall not be less than for every 150 workers at any one time in factory. Each first aid box or cupboard shall be kept in charge of a separate reasonable person who shall hold a certificate in first aid treatment recognized by state government. He should also be readily available during the working hours of factory. In case factory has more than 500 employees, workers are employed in an ambulance or prescribed size containing the prescribed equipment. Nursing staff shall be provided and made readily available at all times. First aid appliances, it is mentioned here, okay? Depending on the number, you should have 150 means you should have first aid, 500 means you should have ambulance. Canteen. Section 46 provides where there is more than 250 workers are employed in any factory, a canteen shall be provided, maintained by the occupier for the use of the workers. The items of the expenditure in running of the canteen, which are not to be taken into account of fixing cost of food, shall be borne by the employer. Shelter, restroom, and lunchrooms. Section 47 provides that where more than 150 workers are employed, adequate and suitable shelters, restrooms, and suitable lunchrooms will be with provision for drinking water shall be provided, maintained for use of the workers. The same shall be sufficiently lighted, ventilated, and shall be maintained in a cool and clean condition. Crunches. Section 48 provides that where more than 30 women workers are employed, there shall be provided and maintained a suitable room for use of children under the age of 6 of such women. The same shall be adequately ventilated and well maintained in a clear and sanitary condition under the charge of a woman trained in the care of children and infants. So it's important. Where there is more than 30 women employees, they should be having a crunches under the charge of a woman. Welfare officer. Section 49 provides if 500 or more than workers are employed in the factory, the occupier shall employ in the factory such number of welfare officer as may be prescribed. Next is working hours for an adult. Chapter 6 of the Act provides that working hour for adults. The chapter provides for working hours in day, weekly working hours, weekly holidays, intervals for rest spread over the duty, night shifts, etc. Section 54 provides no adult worker shall be required or allowed to work in a factory more than 9 hours in a day. Section 55 provides that period of work of adult worker in each day shall be fixed that no period shall exceed 5 hours and that worker shall work for more than 5 years before he has a interval for rest at least half an hour. Section 56 provides that period of work of an adult worker in a factory shall be so arranged that inclusive of his interval for rest, they shall not spread over more than 10.5 hours in any day. Section 51 provides that no adult worker shall be required or allowed to work in a factory more than 48 hours in any week. These are all working hour conditions. No employee shall work more than 9 hours, including work. That person shall not work 10.5 hours, including rest. That person shall not work 10.5 hours. More not in a week, work shall not work more than 48 hours. As far as holidays are concerned, Section 52 provides that no adult worker shall be required or allowed to work in a factory on the first day of the week unless he has or will have a holiday for a whole day on one of the 3 days immediately before or after the said day. The manager of the factory has before the said day or substituted day, whichever is earlier, delivered a notice at the office of the inspector of his intention to require the worker to work on the said day of the day which is to be substituted, displayed a notice that effect in the factory. So crux is no adult worker shall be required to allow to work in a factory on the first day of the week unless he has a holiday for a whole day on one of the 3 days immediately before the said day. Compensatory holidays. Section 53 provides that if a worker is compensatory holidays. Section 53 provides that if a worker is deprived of any of the weekly holidays, he shall be allowed to within the month in which the holidays were due to him within 2 months immediately following that month, compensatory holidays of equal days to holidays so lost shall be given. For duty, Section 57 provides that where a worker in a factory works on a shift which extends beyond midnight, for the purpose of Section 52 and 53, a holiday for a whole day shall mean in case as a period of 24 consecutive hours beginning when the shift ends. The following day for him shall the following day for him shall be mean deemed to be the period of 24 hours beginning when such shift ends, and the hours he has worked after midnight shall be counted in the previous day. Section 58 provides that the works shall not be carried out in any factory by means of of a system of shifts so arranged that more than one relay of workers is engaged in work of the same kind at the same time. So for a whole day shift means in case a period of 24 consecutive hours beginning when the shift ends, the following day for him shall be deemed to be 24 hours beginning when the shift ends. The hours he has worked after midnight shall be counted in the previous day. So there shall be a 24-hour gap between two shift end and shift begin. That's all they are saying. Over time, Section 59 provides that where a worker works in a factory more than 9 hours in any day for more than 48 hours in a week, he shall, in respect of overtime work, be entitled to work at the rate twice his ordinary wage rate. This is very important. As you know, a person shall be working in for not more than if a person is working for more than 9 hours, that person shall be provided wage twice of the ordinary wage rate. It can be 9 hours in a day or 48 hours in a week. Whatever, if every hour after that, the person shall be paid double what he is ordinary paid. Section 860 imposes restriction that no adult worker shall be required or allowed to work in any factory or any day on which he has already been working in any other factory, save in such circumstances as may be prescribed. So double employment is prohibited. So now we discussed double employment is prohibited. Next, there shall be a register of adult workers which shall be maintained showing name of each adult worker, nature of work, group if any he is included, his work group shift, such other particular slip may be required. Employment of women. No exemption from the provisions of Section 54 may be granted in respect of any woman. No woman shall be required or allowed to be working in a factory except between the hours 6 a.m. and 7 p.m. This is very important. State government may authorize the employment of any woman between the hours 10 p.m. and 5 a.m. There shall be no charge of change of shift after a weekly holiday or any other holiday. So main takeaway is 6 a.m. to 7 p.m. only a woman shall be allowed to work. If otherwise required means 10 p.m. to 5 a.m. with the approval of state government you can do. Sections Prohibition of employment of young children. Section 67 provides that no children who has not completed 14th year shall be required or allowed to work in any factory. Adolescent worker. Section 68 provides that children who has completed 14 years or adolescent age shall not be allowed to work in any factory unless a certificate of fitness is granted in custody of manager of the factory. Such child or adolescent carry while he is at work a token giving a reference to such certificate. Certificate of fitness. Section 69 provides a certified surgeon shall, on application of any young person or a parent or a guardian, accompanied by a document signed by the manager of a factory, that such person will be employed therein if certified to be fit for a factory for work in a factory, or an application of manager of the factory in which any young person wishes to work, examine such person and ascertain his fitness for work in a factory. Section 69 subsection 2 provides that certifying surgeon after examination may grant to such young person in, in the prescribed form, or may renew a certificate of fitness to work in a factory as a child if he is satisfied that the young person has completed 14 years, that he has attained the prescribed physical standard, and he is fit to work. A certificate of fitness to provide in a factory as an adult if he is satisfied that young person has completed 14th year and is fit for all works full days work in a factory. The certificate granted child by surgeon will be valid for 12 months from the date thereof. He has the power to revoke also. Working hours for children. Section 71 provides that no children shall be employed or permitted to work in a factory for more than 4.5 hours in any day or during night. The period of work of all children employed in factory shall be limited to 2 shifts, which shall not be overlap or spread more than 5 hours each. Each child shall be employed in only one of the relays, which shall not, except with the previous permission. No female child shall be allowed to work in any factory except 8 a.m. to 7 p.m. So, a female child shall work between 8 a.m. to 7 p.m. A child can work up to 4.5 hours. There shall be 5 hour delay between two shifts. Register of Child Workers. Section 73 provides manager of every factory in which children are employed shall maintain a register including the name of the child of the factory, nature of work, the group if any he is included, where he is a works, the group where his group works on shift, the relay to which he is allotted, the number of certificate fitness granted under Section 69. Annual leave with wages. Section 8 of the Act deals with the annual leave granted workers with wage. Annual leave. Section 79 provides that every worker who has worked for a period of 240 days or more in a factory during a calendar year shall be allowed leave with wages for a number of days calculated at the rate of, for adult, 1 day for every 20 days of work performed by him during the previous calendar year. If a child, 1 day for every 15 days worked by him during the previous calendar year. The following shall be deemed to be days on which the worker has worked for the purpose of occupation of for a computation of the period of 240 or more days, 240 days or more. Any day of layoff agreement or contract as permissible under the standing orders. In case of female worker, maternity leave for any day not exceeding 12 weeks. The leave earned in year prior to that in which the leave is enjoyed, but the above shall not be entitled for a worker to earn leave. The leave admissible shall be exclusive of all holidays, whether occurring during or either end of the each period of leave. In calculating the leave, fraction of leave of half a day or more shall be treated as full day leave. Fraction of less than half a day shall be omitted. So, annual leave. Every adult who has worked for more than 240 days shall be entitled to 1 day for every 20-day worked, 1 day in case of a child, 1 day for every 15-day worked. The following shall be deemed to be days on which workers has worked. Following leave shall also include as days worked. That is female, if it She's taken maternity leave, layoff under any agreement, leave earned in the prior year. However, while calculating leave, any leave taken more than half a day will be treated more 1 day leave. If a leave less than half a day, it will be treated as null, omitted. If a worker does not carry forward of leave, if a worker does not in any calendar year take the whole of the leave allotted to him or leave not taken by him shall be carried over to succeeding year. The total number of leave that may be carried forward shall not exceed 30 in the case of adult and 40 in case of a child. A worker who has applied for leave with wages shall not be granted, shall be entitled to carry forward the leave refused without any limit. So that means a worker who has not in the calendar year taken leave will be allowed to carry forward the leave. In case of adult, 30, child, it is 40. Suppose a person applied for leave and has not been granted, that also can be forward. Availing of leave. A worker may at any time applying in writing to the manager not less than 15 days more before the date on which he wishes to leave to begin to take all the leave or any portion thereof allowable to him during the calendar year. Such application shall be made not less than 30 days before the date of which he wishes to begin the leave. He is employed in a public utility service. An application for leave shall not be refused unless refusal is accordance with the scheme for the time being in operation. Wages during the leave period. Section 80 provides that a worker shall be entitled to wage at the rate equal to the daily average of the total full-time earnings for the days on which he actually worked during the month immediately preceding his leave, exclusive of any overtime bonus, both inclusive of DNS allowance and the cash equivalent of the advantage accruing through the occasional sale to the worker of food grain and other article. In case of worker who has not worked on any day during the calendar month immediately preceding his leave, he shall be paid at a rate equal to the daily wage of the total full-time earning for the days on which he actually worked during the last calendar month preceding in which he actually worked. Advance payment. Section 81 provides that a worker who has been allowed to leave for not less than 4 days in case of an adult and 5 days in case of a child shall be before his leave begins be paid wages due for the period of the leave allowed. Encashment of leave. Section 79 subsection 3 provides that if a worker is discharged and dismissed for service from services or quits his employment or is superannuated, dies while in service during the course of calendar year, he or his heir or nominee shall be entitled to wage in lieu of quantum of leave to which he was entitled immediately before such termination of service. Such payment shall be made before the expiry of the second working day from the date of discharge, dismissal, or quitting, and where the worker is superannuated or dies while in service before the expiry of 2 months from the date on which superannuation or death. It speaks about penalty. Any contravention of the provisions of the Act, the occupier or manager of the factory shall be guilty of an offence punishable with imprisonment for a term which shall be up to 2 years and a fine up to 1 lakh with both. If a contravention continues with a further fine extending to 1,000 rupees for each day. If contravention resulted in accident causing death or serious body injury, the fine shall not be less than 25,000 in case of accident causing death and 5,000 in case of not 5,000 in case there is a serious body injury. Liability of owners. Section 93 provides where there is a permission, premises, separate building are leased to different occupiers for use as separate factories. The owner of premises shall be responsible for provision of maintenance of common facilities and services such as approach roads, drainage, water supply, lighting, and sanitation. The owner of the premises shall be liable as if they were the occupier or manager of a factory for a contravention of the provisions of the Act. Section 94 provides that if any person has been convicted of any offence punishable under 92 and is again guilty of the offence, then contravention of the same, he shall be punishable which may be up to 3 years for imprisonment, fine up, which shall not be less than 10,000, which can extend up to 2 lakh. The court may, for any advocate or special reason, record in writing impose of a fine not less than 10,000. No cognizance shall be taken of any conviction made more than 2 years before the commission of any offence for which the person is subsequently convicted. Penalty for objecting, obstructing inspector. Section 95 provides willful obstruction of an inspector. Whoever obstruct an inspector fails to produce or demand any register, bring shall be punishable for a term no, which may extend to 6 months and a fine up to 10,000 or both. Penalty for contravention of provisions relating to hazardous process. Section 96A provides that whoever fails to comply with the or contravenes mentions of any provisions of Section 41B, 41C, and 41H of the rules made thereunder shall, in respect of such failures or contraventions, be punishable with imprisonment for a period which may extend to 7 years, with fine which may extend to 2 lakhs, or in case of failure to contravention continues, with additional fine which may extend to 5,000 for each day during which he fails and or contravention continues after the conviction for which such failure or contravention. If failure or contravention continues beyond a 1 year after the date of conviction, the offender shall be punishable with imprisonment which may extend up to 10 years. Offenses by workers. Section 97 provides that if any worker employed in any factory contravenes any provisions of this act or rules or order made thereunder, imposing any duty or liability on workers, he shall be punishable with fine which may extend to 500 rupees. Penalty for using false certificate of fitness. Section 98 provides that whoever knowingly uses or attempt to use a certificate of fitness granted to himself, certificate granted to another person, or certificate granted to himself, a certificate granted to another person, or whom have procured such certificate knowingly allows it to be used or attempt to use it by any other person shall be liable for imprisonment but up to 2 months or a fine up to 1,000, which or with both. Penalty for permitting double employment of child. Section 99 provides that if a child works in a factory on any day on which he has already been working in any other factory, the parent or guardian of the child or person having custody or control over him or obtaining any direct benefit from him shall be punishable with fine which may extend up to 10,000 rupees unless it appears to the court that child so worked without the consent or convenience of parents and guardian or persons. Okay, that's all. These are all one points you can keep in mind. If you take a note of that, different points, you may be able to answer. Question can be MCQ. They can put a dash. Any form of direct question you can expect, or you can indirectly a situation they can give, and you should be able to identify what are the provision applicable. That's all. Thank you.